Please note that this video provides general legal education and not tailored legal advice. If you need tailored legal advice, please apply to Q Legal's free legal advice clinic.
Welcome to this Q Legal video on non-disclosure agreements. After watching this video, you will understand what NDAs are, why are they important, when startups should consider using one, and situations where an NDA may not be enough on its own. Imagine this. You've got a brilliant idea, a unique design, or even a marketing strategy. You share it with someone, and a month later, boom, your idea is out there without your name on it. Tough, right? Now that's where an NDA plays an important role to protect confidential information. So, NDAs are legal documents that protect confidential information shared between parties. While confidential information can also be protected under equitable duties of confidence, those claims are generally harder to enforce in practice. Whereas an NDA, by contract, creates clear contractual obligations. When a business needs to share information, such as a design, a process, a business plan, or even a strategy, an NDA is signed before the information is disclosed, and it ensures that the receiving party agrees not to disclose or misuse that information without permission. NDAs can either be one way, where only one party shares information, or mutual, where both parties share information. Now, startups should consider using NDAs when they need to share information with individuals or organizations outside the business. A few common situations may include working with freelancers or hiring new employees who can have access to sensitive information, or even discussing potential collaborations with others. Using an NDA demonstrates that a business values its information and wishes to protect it. Now let's take our fictional business Coffee Clothes as an example. Coffee Clothes is a sustainable startup based in Milan, London. The company turns used coffee grounds into yarn for fashion companies. So if the founders, Jane and Bob, hire a freelance designer to help develop new product samples, they may need to share confidential information such as manufacturing techniques and supplier relationships. Before sharing this information, Coffee Clothes could use a one-way NDA requiring the freelancer to keep that information confidential. Although NDAs are helpful, there are situations where NDA alone may not be enough. While an NDA can cover whatever the parties agree, but in practice, they usually do not try to protect information that is already in public domain. There are situations where another party may not be willing to sign an NDA. For example, many venture capitals will not enter into an NDA as a matter of practice. This is not only because they meet numerous startups, but also because more or less they see the similar ideas frequently. And signing an NDA could expose them to accusations that they have misused confidential information if they later invest in another company with a similar business model. In these cases, founders should be cautious about what they share and avoid disclosing confidential or sensitive information at an early stage. A useful practical tip is to keep initial conversations general and avoid sharing confidential information until it becomes necessary. When discussions progress and confidential details need to be shared, then both parties should sign an NDA before disclosing that information. Thank you for watching this Q Legal video. Now that you've watched this video, you have understood what NDAs are, when they are appropriate for your startup, and the situations where other legal tools are needed to protect your business.
For free legal advice tailored to your business, please go to the Q Legal website and apply to the Q Legal Legal Advice Clinic. For additional videos and other helpful resources, please go to the Q Legal Resource Hub.